By now, just about everyone has heard of the ProPublica article that showed that Supreme Court Justice Clarence Thomas and his wife have for many years accepted lavish vacations from billionaire businessman and right-wing political donor Harlan Crow without disclosing these gifts in required annual reports for judges and other federal employees. By some estimates, the values of these trips that included flights on Crow's private plane and trips on Crow's personal yacht reaches into the hundreds of thousands of dollars. Several ethics experts consulted by ProPublica have stated that Thomas was required by federal ethics rules to disclose the value of this largesse from Harlan Crow. However, Thomas claims that this was just the hospitality of a close friend and that he was not required to disclose the value of these vacations that were paid for by Crow. For his part, Crow has claimed that these luxury vacations were in no way intended to influence any of Justice Thomas's actions and that they were just friends having a good time on Crow's dime. However, the ProPublica article pointed out that Crow donated $500,000 to a Tea Party group set up by Thomas's wife, Ginny, and that $120,000 of that money ended up being paid as salary to Thomas's wife. In response to the revelations of the ProPublica article, Justice Thomas acknowledged that he had joined Harlan Crow and his wife on a number of family trips over the years. Thomas went on to describe Crow and Crow's wife as being among his dearest friends. Thomas then went on to claim that because these trips were just hospitality provided by Crow, he was under no obligation to disclose them. However, in making this claim, Justice Thomas managed to hoist himself on his own petard. Thomas claimed that the Ethics in Government Act, which was passed in response to the revelations of the Watergate era, and which applies to all federal employees, including Supreme Court justices, has a carve-out that exempts personal hospitality from reporting requirements. But this is where the cheese gets binding for Thomas. The section that Thomas relies upon does indeed have a carve-out for food, lodging, or entertainment received as personal hospitality. But what is not included in the carve-out is transportation. This means that Thomas had an obligation to report the value of transportation provided by Crow. And this indeed was significant, since many of Thomas's vacations with the Crows included travel on Crow's private jet or on Crow's personal yacht. The fair market value of this transportation clearly exceeded $100, and Thomas clearly violated the Ethics in Government Act by failing to disclose each instance of transportation provided by Crow. Some of you may know that many decades ago I spent 4 years in Philadelphia attending the University of Pennsylvania for my PhD studies in physics. In those days, Philadelphia police officers were seriously underpaid for the work they did, and many were not above accepting a bit of extra compensation now and then, often in the form of free meals or an occasional gratuity to overlook a traffic infraction, etc. As a result, we often referred to members of the Philadelphia police force as the best cops that money could buy. And so it is with Justice Thomas. Clearly, it beggars the imagination to think that the munificent largesse Harlan Crow has bestowed on Clarence and Ginny Thomas over decades has been entirely without an explanation of anything in return. So I repeat, in my humble opinion, Clarence Thomas is the best judge that money can buy. And remember that whatever else you may think about Clarence Thomas and the current condition of the highest court in our land, you really can't make this stuff up.